right here.
Yeah.
Okay, so Stephanie Cruz
Oh.
sent a request. Now, I included Caitlin. I wrote to
The
Caitlin.
Heritage Foundation. Okay. I don't
Oh,
know.
they provided an email too, right?
And this person, Stephanie, does not wish to speak. I don't.
Oh, they're separate. Okay.
They work together,
But they're.
but I don't know if they ever communicated with Caitlin to get on the
She
list.
can somebody respond to her and tell her she can.
Thank you.
Thanks. Good morning, everybody. We have a packed judiciary hearing today. We are going to be hearing testimony on and voting out House Bills 5207 to 5215, testimony and voting out Senate Bill 592, and voting out Senate Bill 410 as well. Madam Clerk, can you please take the roll?
Chair Breen,
Present.
Representatives Edwards,
Here.
Carter,
Present.
Hope, here, Arbit, Devendorf,
Here.
Hoskins,
Here.
Cerniglu,
Here.
Fink,
Here.
Wenzel,
Here.
Wozniak,
Here.
Outman,
Here.
Johnson. Here. Madam Chair, you have 12 members present. You do have a quorum.
Thank you. First, we are going to take up Senate Bill 592 as we want Senator Bayer to get on back to the Senate so they can continue on with their business this morning.
Thank you, Madam
And
Chair.
we are also having up here Ashley Steffen and Matt Walker from the Michigan Department of Attorney General. Senator Bayer, please tell us about your bill.
Thank you very much, Madam Chair and members of the committee. Thank you for hearing our testimony today. This bill 592, Senate Bill 592, modifies the Opioid Liability Litigation Act from last term. Many of you will remember that basically what it does is make sure that we receive the settlement funds from the National Opioid Settlement Activity. Senate Bill 5995 passed unanimously through the Senate and almost unanimously through the House last term. So in June of this year, the Attorney General announced a settlement with Walgreens Pharmacy worth $338 million for their role in Michigan's epidemic. And we also expect to receive shortly over $445 million from national settlements with Teva Pharmaceuticals, Allergan Pharmaceuticals, CVS Pharmacy, and Walmart. To ensure that Michigan receives the full amount of these settlement funds, the settlements must be added to the Opioid Liability Litigation Act from last term. So I'm asking for your support for SB 592 to add them to make sure Michigan gets its share of those funds. And with me again is Ashley Steffen and Matt Walker from the Attorney General's office if you have any technical questions.
Any questions from the committee? A-okay.
Thank you.
Thank you so much. And with that, I'm going to take a motion from Representative Edwards to report Senate Bill 592 with recommendation. Madam Clerk, please call the vote.
Chair Breen,
Aye.
Representatives Edwards,
Yes.
Carter,
Yes.
Hope, yes, Arbit, Devendorf,
Here. Yes.
Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Yes.
Wenzel,
Yes.
Wozniak,
Yes.
Outman,
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. Senate Bill 592 is reported with recommendation.
Thank you. We are now going to take up Senate Bill 410. I will take a motion to report Senate Bill 410 from Representative Carter. To report that with recommendation, Madam Clerk, please call the vote.
Chair Breen,
Aye.
Representatives Edwards,
Yes.
Carter,
Yes.
Hope, yes, Arbit, Devendorf,
Yes.
Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Pass.
Wenzel,
Pass.
Wozniak,
Pass.
Outman,
Pass.
Johnson.
Pass.
Madam Chair, you have 7 yeas, 0 nays, and 5 pass. Senate Bill 410 is reported with recommendation.
Thank you. We are now going to take some continued testimony in House Bills 4207 through 4215. And we have Professor Courtney Jocelyn here to testify over Zoom. I'm sorry, 5207. I said that wrong. 5207 to 5215. My bad.
Wonderful. Well, thank you so much for your consideration of this important legislation. So my name is Courtney Jocelyn.
Courtney,
a
I'm so
Martin Luther
sorry.
King
One
Jr.
second.
Professor of Law at UC.
I'm so sorry. Can we stop for one moment? We're going to take a motion to reconsider the vote on Senate Bill 410. We need to do a motion for us to reconsider.
Yes.
Okay, motion to reconsider the Senate vote for Senate Bill 410.
That was on me, I messed up.
Okay. Madam Clerk, please
On
call.
the motion, okay,
Yeah.
is the motion made by Representative Outman?
Motion made by Representative Outman.
Okay. On the motion to reconsider.
On the motion to reconsider the vote.
By which Senate Bill 410 was taken. So this is the motion to reconsider that vote. Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. The motion is adopted. And now we need a motion.
And now we are going to take another motion from Representative Carter to report Senate Bill 410 from Senator Irwin regarding drug immunity. Motion is from Representative Carter. Madam
To
Clerk?
report Senate Bill 410 with recommendation, Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 3 pass. Senate Bill 410 is reported with recommendation.
Okay. Everybody good? All right, moving on. I'm so sorry to Professor Courtney Jocelyn to give us her testimony again here on House Bills 5207 to 5215. My apologies, Professor. Please start again.
No. Thank you so much for having me today, and thank you for your consideration of this legislation. So, as I said, I'm a Martin Luther King Jr. Professor of Law at UC Davis School of Law, where I teach family law and constitutional law, among other courses. And my research explores family and relationship recognition with a particular focus on the parent-child relationship. And most relevant to today's hearing, I served as the reporter for the Uniform Parentage Act of 2017, upon which this bill package is based. So last week you heard testimony from Representative Steckloff, as well as 3 people with lived experience related to this bill. And today, my goal is to make 2 key points. The first is that this bill package is based on best practice models. It draws largely from the most recent version of the Uniform Parentage Act, or the UPA. And as with other uniform acts, the drafting process for the UPA of 2017 was very careful and deliberate. We drew from the collective experience from the drafting committee, as well as expert observers from leading professional organizations, including the ABA and the Federal Office of Child Support Enforcement. Since its inception 50 years ago, the UPA has always been child-centered and child-centric, guided by 2 principles. First, to eliminate discrimination against children based on the circumstances of their birth. And then second, to protect children's relationships with the people who are and who have been parenting them. And these 2 key principles are related. Having comprehensive and clear parentage rules that apply to all children fosters the welfare and well-being of children. This takes me to my second point, which is that currently Michigan parentage laws are not comprehensive. And in this way, they are out of step and out of line with developments we are seeing around the country. And critically, the people who are most harmed by this are the children. Today, Michigan is the only remaining state in the country with a broad criminal ban on surrogacy. This law was enacted in the 1980s, and the understanding and approach to surrogacy has developed dramatically since that time. Indeed, since 1992, every enacted surrogacy law has been one that permits and regulates surrogacy. These legislatures have concluded, correctly in my view, that this is the best way to protect the parties and, most importantly, to protect the children who are born through surrogacy. And drawing from best practice, that is exactly what this bill package does. Michigan law is also out of step with regards to assisted reproduction. The existing provisions simply fail to protect many children who are born through assisted reproduction. And what that means in practice is that those children often lack a legally recognized relationship with people that they view and rely upon as their parents. So in sum, the Michigan Family Protection Act is a well-crafted bill based on best practices that would update outdated law and protect all of Michigan's children. I'm happy to answer any questions, and thank you again for your consideration of this important bill package.
Thank you. Representative Fink has a question for you.
Thanks, Madam Chair. Yep. Professor, my question is, I was doing some research about these bills. I came across a law review article, which admittedly is from some time ago, but doesn't appear, the analysis in it doesn't appear to really have fallen out of date. It's an article called The Black Surrogate Mother by Anita Allen. Are you familiar with that article or the arguments there? So one of the things she says is, I believe that policymakers should discourage surrogacy, chiefly by refusing to enforce commercial surrogacy agreements, ascribing to surrogates parental rights, which they may voluntarily relinquish only after the birth of a child they are paid to carry, and by making no distinction between genetic and gestational surrogates when it comes to the assignment of parental rights. And I think that last point is covered in this legislation. She continues to say, legislation shaped around points 1 and 3 would increase the risks of entering into surrogacy agreements for the economically more powerful parties, the consumers and brokers of surrogacy, and decrease the risk of surrogacy agreements for the less economically powerful, the surrogates. Now, this legislation, I think, expressly contemplates that economic disparity is going to be true, because we require in this legislation, or we would require, that the payers of the surrogate mother have to pay for her attorney to represent her in drafting the agreement. So what about that almost definitional economic disparity between the parties here?
Yeah, so absolutely. Initially, when commercial surrogacy was first practiced back in the 1980s, when this existing legislation was passed, there was concern that it would result in particularly poor, low-income women, especially women of color, being coerced into acting as surrogates. But what we have seen in the 40 years since that time is that while it is true that there often is a difference in the economic status of the intended parents and the people acting as surrogates, that it is not the case that people acting as surrogates tend to be low income. They actually tend to be middle class. And what the research demonstrates is that here in the United States, the experience of people acting as surrogates is largely positive, and they do not report feeling coercion in the process, and having the intended parents pay for counsel for people acting as surrogates just ensures that the basic safeguards in this bill package are fulfilled, making sure that all parties are represented by counsel, making sure that all parties are adequately advised of their rights and that they're making informed choices here and are not experiencing coercion. And again, this represents kind of best practices. As I said, we have seen every state since 1992 that has passed surrogacy legislation, has passed legislation that looks like this, that permits surrogacy, but regulates it and puts in place basic safeguards to make sure that the rights and interests of all of the parties here are adequately protected.
Just as a very quick follow-up, you would agree that Michigan law currently permits surrogacy, it just doesn't permit surrogacy agreements, right? In other words, a person could carry a baby that's generated by somebody else's genetic material, and through one of these processes that we're talking about in this legislation, we just couldn't enforce a contract under our current law, right?
Well, it does also, Michigan is the only state that also potentially imposes criminal penalties on parties involved in certain types of surrogacy agreements.
Yeah, but it's the agreement that's illegal, not the surrogacy, right?
Well, the
Representative
parties
Fink,
who are
the agreement
participating
makes
in that
surrogacy illegal,
arrangement do
so-
risk the possibility of criminal penalties for their participation in those arrangements.
I understand that the agreement's illegal. What I'm saying is women act as surrogates in Michigan right now, and they're not subject to criminal penalty unless there's a contract.
Representative Fink, that's been asked and answered. Any additional questions? Representative Johnson?
Thank you, Madam Chair. Thank you for your testimony. How many states have adopted the Uniform Parentage Act?
So over half the states in the United States have parentage laws that are based on some version of the Uniform Parentage Act. There are now 3 versions, and we so far have 7 states that have enacted the most recent version of the Parentage Act, UPA 2017.
Professor, how many states currently prohibit surrogacy contracts?
So it's a little tricky to count, but I would put it as 5 states that currently have statutes that ban surrogacy. In one state, for example, though, there's a court that's held that unconstitutional, so there's some dispute about the exact number. But again, Michigan is the only remaining state that has a criminal ban on surrogacy. A number of other states that had fallen in that category have more recently repealed their bans. So that includes DC, Washington State, and New York.
Thank you. Any additional questions for the professor? No? All right. Thank you for your time. We appreciate it.
Thank you for having me.
Sure. I'd like now to call up Rebecca Master from the Catholic Conference. Masty, sorry. Mm-hmm.
Thank you. Sorry. I wasn't expecting to be called so early. So appreciate the opportunity. Chair Breen and members of the committee, as mentioned, I am Rebecca Masty, representing the Michigan Catholic Conference. And I appreciate the opportunity today to express opposition to House Bills 5207 through 5215. This bill package makes significant changes to the state's family and parentage laws, as well as intestate succession and inheritance rights, all of which warrant individual attention. But for time's sake, I want to focus on concern over surrogacy contracts and compensation. But first, I do want to raise one other significant point that might otherwise be overshadowed. Current law finds parentage through birth, genetics, or adoption by a married couple or a single individual. Yet, as currently written, these bills would appear to significantly diverge from this norm to allow an unspecified number of people to contract or consent to intentionally create a child that they agree to parent, whether they have any genetic tie to the child or even any relationship with each other, as there is no requirement intended parents even share the same household. But turning to surrogacy, I want to acknowledge the suffering of those who experience infertility and recognize the value in the desire to have and raise a child. While all babies are a blessing and each person has the same dignity regardless of their origin, surrogacy is much more than just helping someone have a baby. The experience of other states and countries that have legalized surrogacy contracts show that the practice is rife with social, moral, and legal problems, not the least of which is the commodification of children and the exploitation of often vulnerable women. It also poses the potential for the surrogate, the baby, or both to become victims of human trafficking. Emerging evidence now shows the risk that surrogacy poses to both the life and health of the surrogate mother and the baby as a result of more complicated pregnancies being found in surrogacy than those with non-surrogate pregnancies. A 2018 United Nations report by the Human Rights Council recognizes that, quote, commercial surrogacy often involves abusive practices, end quote, and directly challenges human rights norms, noting that some commercial surrogacy practices violate the international prohibition on the sale of children. Separately, this same report highlighted abusive practices, including a case where 2 prominent surrogacy attorneys in California were criminally convicted for selling babies. They created a baby selling ring and deceived both the courts and prospective parents. With the use of surrogates, they amassed an inventory of unborn babies, which they sold for over $100,000 each. Disturbingly, one of the attorneys later admitted that her legal actions were just the tip of the iceberg among a corrupt and billion-dollar industry. What else is occurring within this industry that is created when surrogacy is commercialized? In courts and in the news, there have been instances where unregulated surrogacy agencies took fraudulent payments from intended parents. On the flip side, in France, a surrogate was found guilty for defrauding prospective parents she had entered into surrogacy agreements with by telling them that the baby was stillborn or had died, when in fact she sold the healthy baby to another couple. And in 2021, a California woman came forward to tell her surrogacy story about how she found out from the FBI that the intended father was involved in a baby selling ring and other crimes. So despite attempts to regulate surrogacy, abusive practices still occur. Surrogacy arrangements also inherently exploit women. This is recognized by many countries throughout the world to be a human rights violation. For example, the European Union in 2015 adopted a resolution advising that surrogacy, quote, be prohibited and treated as a matter of urgency and human rights instruments, end quote, and that the practice undermines, quote, the dignity of the woman since her body and its reproductive functions are used as a commodity, end quote. Just want to turn back to the key recommendations found in the previous United Nations report I mentioned from 2018. They recommended that member states create safeguards to prevent the sale of children in the context of commercial surrogacy, which should include either the prohibition of commercial surrogacy until and unless properly regulated systems are put in place to ensure that the prohibition on sale of children is upheld, or strict regulation of commercial surrogacy, which ensures that the surrogate mother retains parentage and parental responsibility at birth, and that all payments made to the surrogate mother are made prior to any legal or physical transfer of the child and are non-reimbursable except in cases of fraud. So with that, I just want to close and note how this bill package, as previously mentioned, opens Michigan to commercialize surrogacy, reproductive commerce, and potential reproductive exploitation. Let us also not lose sight that at the core of such agreements is a contract for a human being. I encourage you to oppose this package of bills. Thank you.
Thank you, Representative Fink.
Thank you, Madam Chair, and thanks for your testimony, Ms. Masti. Have you looked at the sections of the Surrogate Parenting Act besides the one prohibiting contracts for surrogacy generally, but the ones about contracts for surrogacy with an unemancipated minor female, a female diagnosed as being intellectually disabled, and so on? It appears that those would also be repealed by this legislation. Is that your understanding? Yes.
And currently those result in felonies as taking advantage of a minor child or a developmentally disabled individual.
Thank you.
Any other questions? Representative Wozniak?
Thank you, Madam Chair. You brought up commercialization of surrogacy. Are you touching on meaning that this is like human trafficking?
Well, there have been instances of that, but by recognizing that with surrogacy contracts, there comes an industry, there comes advertising, there comes brokers, there comes surrogacy attorneys. There's a whole industry around the creation and execution of these contracts and matching surrogates with parents, as opposed to our current practice, which is altruistic surrogacy, which typically would occur between friends or family members.
So you're actually selling the body, the person, the baby, right?
There have been instances where that has happened. I recognized mentioned a couple of those that have been found in the news or throughout the courts.
Thank you.
Have you found any instances in other states of this actually being human trafficking and charged as such?
The baby selling ring, obviously the one in California that I mentioned.
Okay, but as far as I understand it, this package has nothing to do with human trafficking. In fact, we still have laws on the books that specifically prohibit human trafficking. That's your understanding as well?
Correct.
Okay.
We're just saying that it lends to the possibility of abuses.
Okay. Thank you. Seeing no further questions, we have Genevieve Marnin from Right to Life of Michigan.
Thank you, Madam Chair and members of the committee. I appreciate a moment to talk about these bills. There are so many troubling issues with House Bills 5207 to 5215 that it would take volumes to fully dissect them all. Authorizing abortion clauses in legally binding surrogacy contracts, erasing moms and dads from our parentage laws, putting women's bodies under contract, encouraging the largely unregulated multi-billion-dollar fertility industry to expand in our state, thus creating untold numbers of embryos, aka unborn children, to be discarded or used for research, and so much more. Michigan law currently allows for uncompensated altruistic surrogacy for adult women, and Michigan law allows for in vitro fertilization. Michigan law allows intended parents, whether they are genetically related to the child or not, to adopt and have their names listed on the birth certificate. What Michigan law does not allow is legally binding compensated surrogacy contracts, the use of a contract to determine parentage without court oversight, and the use of minors or developmentally disabled women as surrogates. Yet House Bill 5209 would repeal the criminal penalty for using minors or developmentally disabled women as surrogates. I don't think that's a good idea. Do you? We are one of two remaining states, Nebraska being the other, which prohibit legally binding contractual surrogacy agreements. Providing payment for services rendered turns the generous act of being an altruistic surrogate into a money-making proposition, which in turn creates a market that can and does exploit poor and vulnerable women. Michigan law recognizes that gestational carriers and the babies they carry need safeguards against exploitation and commodification. Banning compensated surrogacy and requiring the legal adoption of children born of surrogates helps provide those safeguards. In most parts of Europe and much of Asia, surrogacy is completely banned. Countries such as Germany, Sweden, and Japan do not even allow altruistic surrogacy. Others, like Canada, Australia, and Great Britain, ban commercial surrogacy but allow some forms of altruistic surrogacy, like Michigan does. Thailand and India once permitted commercial surrogacy and surrogacy tourism, as these bills will allow, and they changed their laws after realizing how exploitive surrogacy contracts are, and they now ban commercial surrogacy. Almost without exception, surrogacy contracts contain abortion clauses. Abortion clauses dictate that the gestational carrier submit to an abortion at the behest of the purchasing parent or parents if those parents change their minds, discover a fetal anomaly, or if there are more babies that survive the embryo transfer than they want. While a woman cannot be forced to abort, if she refuses, heavy legal and financial consequences can be imposed. Just a few years ago, we passed comprehensive legislation directed at tackling the problem of human trafficking. Included in the law is the definition of coercion, which is, quote, a belief that failure to perform an act will result in financial harm. Surrogacy contracts clearly contain coercion of financial harm to a surrogate who refuses to abort a child if the purchasing parent so dictates, and the contract stipulates. Surrogacy horror stories have surfaced, which include baby selling rings, surrogate trafficking, and baby hoarding. A Japanese man was discovered with 16 infants living in a condo, all purchased with donor eggs and surrogates that he acquired through a surrogacy brokerage firm. Surrogate Melissa Cook from California was contracted by a third-party broker to be a gestational carrier for a man she had never met. The man purchased eggs and paid to have embryos created and implanted in Melissa's body, triplets. The disabled man living in deplorable conditions in his parents' basement. Yet he was allowed to manage to buy eggs, purchase a womb, and sign a contract, and then was allowed to take legal possession of these 3 babies he could not care for. These situations were made possible because surrogacy contracts are often brokered by third-party attorneys, and the attendant parent has no contact with the surrogate, and the legal adoption requirement is bypassed. The law in Michigan allows for altruistic surrogacy, thus requiring the surrogate to at least meet the intended parents, and it requires legal adoption, thus allowing the state to investigate and thwart any situation which may be dangerous to the child. I do understand the desire to have one's own child. I understand that some believe this package will help infertile couples have children, but I urge you to look at the current law and the unintended consequences of adopting House Bills 5207 to 5215 and vote no. Thank you.
Quick question. There are laws prohibiting minors from entering into contracts. Is that correct?
Right now,
Okay.
your bill would repeal the criminal ban on that.
On all laws? No, there are. It's to my understanding that minors are not allowed to enter into a legally binding contract.
Now, looking at this, it says you have to be 21 to be a surrogate, but there are no criminal penalties for it if you are not, because your law would remove the criminal penalties for that.
But minors still, under the current law,
There
under this law, minors are not allowed into entering legally binding contracts.
But there's no criminal penalty for doing so.
Okay. Well, we're going to make sure that doesn't happen. I can guarantee you that. So, thank you. Any other questions? Oh, Representative Johnson.
Thank you, Madam Chair. Thanks for your testimony.
You're welcome.
Very thorough. Do you know anything about the health outcomes, the differences between a surrogate mother and birth mother? Are they the same?
No, in fact, again, I wish we had a reproductive health care specialist here to testify, but based on studies that have been done, the risk to the surrogate mother compared to a traditional mother birth is much greater. There's much higher risk of multiple births, preeclampsia, hemorrhage, postpartum depression. There's a whole host of health consequences that accompany being a surrogate of a child for whom you are not genetically related.
And you mentioned a lot of countries that have a ban on it, but have there been any countries that have taken legislation like this, proposed here, and we see the good or the bad from that?
Well, we've seen a whole host of problems, especially in places like India and Thailand, which were pretty liberal on their gestational carrier laws, their surrogacy laws, and there have been so many stories. I could fill volumes, so I said it could take me all day to dissect all this. But they've pulled back their laws after realizing all of the problems that were associated with commercial surrogacy.
Representative Hope.
Yeah, a few things. You mentioned the financial penalties and burdens that a potential surrogate could realize. Is it not financially burdensome to have a child anyway? That's just kind of a comment, not really a question. You mentioned the guy in the basement. I don't remember if he was in the United States or where exactly, but
North Carolina.
Wouldn't he be free to reproduce anyway?
Yes, he would be free to
Okay.
reproduce anyway, but my guess is that he might be limited in his options.
And
Natural selection being a thing.
And then I don't understand why it's what the problem is with a private agreement to have a baby, but it's not okay for the government it's okay for the government to compel someone to have a baby. That's just something I'll have to work out, I guess.
I'm sorry, was there a question there? I apologize. Okay.
It's to my understanding that a disabled individual, somebody who is mentally or developmentally disabled, they would need a conservator and a guardian to sign off on any type of an agreement, correct? So you would not be able to get somebody who is mentally or
Unless their guardian signed off.
in
I mean, under the current law, that would be a criminal penalty. for inducing and this, in fact, that was just changed. In fact, it was broad bipartisan support on that law. It was, I think, 2014 we updated the law.
But still, somebody who is developmentally disabled would not be able to freely enter into a surrogacy agreement without getting their guardian to sign off on it,
Well, that's
correct?
assuming they all have a guardian. Not every developmentally disabled child or person has a guardian. Not all of them. Or they're limited. Yes, but you're probably right. I am not an expert on estate planning, and that maybe Representative Wozniak could address that.
And surrogacy agreements would certainly be tailored, as far as I'm understanding the way these bills are going forward, to prohibit any minors or people who are developmentally disabled from entering into surrogacy agreements.
That's what the law currently says, but there are no criminal penalties for violating it.
Okay. Representative Fink, and then after this, I need everybody to keep their questions very short and to the point.
Yeah, this is just to clarify this colloquy you're in right now. The point is not that without the prohibitions of MCL 722-857, it will be legal to contract with a minor or a developmentally disabled person. It will just be that the state will not penalize you criminally for it, whereas we do today. And so the question is, why would we repeal those even if we're allowing surrogacy agreements in general, right?
That's exactly right.
Okay,
Thank you.
thanks.
Representative Arbit.
Thank you, Madam Chair. Thank you so much for being here. I think this is an issue that impacts so many people across the state, and so I'm wondering, if we were to look at, alternate ideas, for the tens of thousands of gay and lesbian couples in the state of Michigan who would like to have, a child that is biologically related to at least, one partner in the couple. How would you suggest that they do that if not for, legalizing surrogacy, commercial surrogacy in the state of Michigan?
So I believe most of the time lesbian couples can conceive and bear their own children. I mean, I'm not an expert on that, but my understanding is that not the case with assisted reproductive technology.
Right.
Right. No. But I'm not. They wouldn't need to use a surrogate. Am I incorrect on that? I'm not trying to be insensitive. I just want to make sure I'm clear on what you're asking.
Well, I'm asking, how would you suggest, if not for surrogacy? I mean,
right now, the current law would allow, like, a gay couple, men, that they want to contract a surrogate. It's perfectly legal in the state of Michigan to do so.
Okay, thank you.
Representative Devendorf.
I just want to clarify, as a queer femme who could reproduce, but maybe not for much longer, I would not claim that most lesbians in a couple, as part of a couple, produce children themselves, because there are any number of obstacles that can be put in our place, including the discrimination that has occurred up until this point in history, making it more difficult for us to have our own children at younger ages. So surrogacy is that much more important to us, to have the option to have families, period. We need as many options as possible, and Lord knows the LGBT community has been statistically disproportionately more willing to offer homes and to really support a loving home and the parenting of children under so many circumstances that the average person would not consider. So surrogacy is essential. Thank you. No question. That's just clarification.
Thank you.
Thank you very much. Oh, wait, we have another question? Yes. Representative Edwards.
I just had a question of clarification. Based upon your testimony, are you saying that babies are being sold and human trafficked and all that stuff? Is that what you're saying? I
am saying that has happened around the world. In fact, I could go on. There was a baby selling, and we got to remember, sex trafficking is a real problem. We recognize that in this country. Human trafficking is a real problem, but some traffickers have realized that surrogacy trafficking is far more lucrative, and they busted a surrogacy trafficking ring in Africa. Women were being held, literally handcuffed to beds, being breeded, for lack of a better word, and those babies were being sold under the guise of consensual contracts. Because again, the surrogate never meets the intended parent in most cases when you're dealing with a third-party broker. That's all we're saying. That doesn't happen. I understand that most of the people who will utilize this are probably people like the bill's sponsor. I understand that. But I'm just having you guys all realize that there are There's a reason for why Michigan's law is the way it is and why it's protective. We don't want to see baby selling rings here in our state.
And to be clear, nothing in these bills, to your understanding, legalizes prostitution, taking people hostage, or forced surrogacy.
Correct. But removing,
Okay.
but by putting a third-party surrogacy broker in between the intended parent and the surrogate, it makes it possible for some of the scenarios that we've laid out today.
Okay. I'm personally not a fan of that slippery slope argument, but I understand what you're saying, and thank you for your testimony. I'd like to call up now Tammy Myers and Alex Kramer.
Hi, thank you for having me. When my son was born this summer in Ann Arbor, my husband and I discovered that our names were nowhere to be found on his hospital bracelets. Instead, our surrogate's name was on our son's bracelet. This meant that we were constantly having to remind the hospital that we were his parents. Because surrogacy is not legally recognized in Michigan, many of the medical staff did not know how to handle us. We didn't have this issue for our first son, who was born through surrogacy in rural Indiana. If surrogacy were legally recognized and regulated in Michigan, we would not have had to spend the first day with our newborn advocating to be treated like his parents. My name is Alex Kramer, and this bill is important to me because I am a mother twice over through surrogacy. I was born with a complex congenital heart defect and have always known that it would not be safe for me to carry a pregnancy. My husband and I live here in Michigan, but quickly learned that Michigan is not a friendly place for surrogacy. Because of this, our first son was born in Indiana in 2020. When we decided we wanted to have a second child, we moved forward with a surrogacy journey here in Michigan with our generous friend as our surrogate. However, in Michigan, the law remains unclear as to who will be legally considered the child's parents upon birth. During this process, we had to go before a judge to determine whether we would be considered the legal parents of our own child. Luckily, the judge ruled in our favor, but after all of the years of financial and emotional turmoil, being constantly reminded that the law may or may not recognize us as the parents of our child just highlighted the worst feelings of inadequacy. We were lucky to obtain a pre-birth order from the judge, and we were lucky that we had the resources and knowledge to make sure our son received excellent care. If we had not done the legwork, if we weren't well-versed in the world of surrogacy, if the judge hadn't ruled in our favor, our child and our family may not have been protected. Should Michigan parents have to hope for good luck as they build their families? I don't think so. I'm here in strong support of the Michigan Family Protection Act. Thank you.
Thank you for having me as well. My name is Tammy Myers. I'm a wife, a mother, a breast cancer survivor, and an advocate for positive change in Michigan. I'm here with you today because my very public legal battle for the rights of my biological twins is proof that Michigan's outdated parentage laws are a source of unnecessary trauma for families like mine. Becoming a mother is a dream that began when I was a young girl, a dream that became a reality when my husband and I welcomed our daughter Corinne in 2012. But when we started trying for our second child in 2015, the unthinkable happened. At the age of 33, I was diagnosed with a very aggressive form of breast cancer. My first questions were, how long do I have, and can I have another baby? We were able to do an emergency egg harvest before my chemotherapy treatments began, but I would never be able to carry another child in my body. Over the next several years, I endured countless treatments, over 25 surgeries, but I remained hopeful. We started our search for a gestational carrier after receiving a small grant to help us begin the very costly process in 2019. For the first time in years, I felt like we were turning a corner, that we had earned a new beginning. Most of all, I was excited to have an opportunity to rejoice in the happiness of growing my family, something that so many around me are blessed to take for granted. In June of 2020, we found out that our first and only embryo transfer was successful. We were expecting twins. We knew that Michigan laws were outdated and that our gestational carrier, Lauren, and her husband might legally be seen as the parents of our babies, which was unfortunate. But we hoped that we could convince the court to declare us as the legal parents, given our circumstances, and because some Michigan courts were already granting pre-birth orders in situations like ours. Sadly, 2 Grand Rapids judges rejected our requests without even granting a trial for us to share our story. Our son and daughter were born 2 months premature, although there was an immense amount of fear because our babies were making their entrance during a worldwide pandemic, and we had 0 legal rights to them. Hospital staff pulled strings to ensure we were present for their birth and that we remained by their side in the NICU. Within 24 hours, they drafted paperwork allowing Lauren to sign over her rights to making medical decisions for our babies so that we were the ones that consented to life-saving measures. However, the state of Michigan wasn't able to make those exceptions. Lauren and her husband, Jonathan, were listed on the birth certificates as the parents of our children, and our legal battle spiraled out of control. Moments that should have been full of joy and excitement were replaced by fear, frustration, and sadness. Hundreds of thousands of dollars in medical bills piled up, and we were unable to place our babies on our health insurance because we were not legally their parents. Medicaid paid for their lengthy and costly hospital stay in the NICU. To correct the birth certificates, we were ultimately forced to adopt our own children. The process was heartbreaking, offensive, and extremely costly. But the hardest part is knowing that the legal chaos overshadowed the first 23 months of our children's lives, moments that we cannot replace. Our adoption was finalized just 1 month before our twins' 2nd birthday. If the proposed legislation had been in place when our babies were born, we would have been correctly listed as the parents at the hospital. We would have been able to avoid this legal nightmare. We would have been able to put the babies on our insurance, and we would have been able to focus on what mattered most, the health and happiness of our tiny miracles. Although our legal nightmare is officially behind us, I'm not sure I will have closure until I know that families like mine will not have to suffer through this process in the future. I am also here in strong support of the Michigan Family Protection Act. Thank you again for your time.
Thank you both for your testimony. I'd followed some of this on the news, and it sounds like eventually you had a good outcome. Now, Tammy, we heard some of your testimony. Could you tell us a bit more specifically about what these changes in the law that are being proposed, how they could have specifically helped you along the way?
For us, the hardest part seemed like getting through breast cancer and then getting to the point where I could afford to take the steps and find a surrogate who was willing to bless our family with his amazing gift. And we got there and had the green light. We truly thought, following the legal advice and going through the steps of the procedure, we could have a situation similar to Alex, and maybe we could avoid a lengthy legal battle, that we could rejoice in the happiness that came from growing our family and feeling complete and just being at home with our little ones. If this legislation had have been passed before my situation, I wouldn't have had to go through all of that for 2 years. We would have just lived in the moment, enjoyed our babies, and we wouldn't still be worried about paying the financial situation that we've endured because of it.
Okay. Thank you. Do we have questions from any other? Thank you. Representative Johnson?
Thank you, Madam Chair. I'm so glad you were able to be parents, and congratulations.
Thank you.
Good job navigating through all the difficulty. I'm glad you were able to use surrogacy in Michigan. Was anybody prosecuted for any part of this surrogacy part? So it worked in Michigan. I just submit to you, I've been through custody battles, divorce, child support negotiation, the whole gamut of court proceedings, and they are painful, especially around children. There are many judges who don't even understand the law. That is the problem, because the law in Michigan supports what you were able to do. And the hiccups at the hospital, the judges, the courts, is because the clarification needs to be made. It is legal. No one got prosecuted, correct?
No one was prosecuted.
Right? Were they even tried for anything? Were they ever attempted to be arrested, anything like that?
We were not. It was just the emotional struggle that we were all put through, with full support of our gestational carrier. You know, she stands with us in this and recognizes that it was a lot for all of us, and it's something that's going to take years to really work through.
And even if this bill package passes, we're still going to have errors like that because of human error. Hospitals not knowing, new people come from another state where it's different, handled differently. These errors need to be cleaned up across the board in all sorts of court proceedings. And thank you for bearing through it. If you polled the room, I bet we would all have a story of a court proceeding that was mishandled because the judge, the lawyers, whoever, prosecutors did not know how to handle it. And maybe we should do that. Thank you.
Thank you.
It's to my understanding this package of bills is going to help make sure that those errors don't occur and we don't have to have those court proceedings and we don't need that indecision, and it will make it so that you don't have to adopt your own children. That's correct?
That is correct from my understanding.
Okay.
So I can speak a little bit to this because I have done surrogacy journeys both here in Michigan and in another state. In Indiana, when we had our first son, the pre-birth order was just paperwork. It was just a formality. And here in Michigan, it was waiting for 8 months to have our time with the judge to have her determine whether or not we would be legally considered our child's parents.
And this package of bills would have helped you avoid that?
Yes.
Okay, thank you. Representative Wozniak.
Thank you, Madam Chair. And just following up on Representative Johnson's questions or statements, were you in the same court?
No.
Okay. And maybe as a layperson, you can answer that. How did you feel about the proficiency of the judge that was executing your cases?
Mine was great, but again, it was just the luck of the draw. Like our lawyers were telling us, it just depends who you get that day, whether or not you'll get to be your child's parents.
And I can second that notion as well. Unfortunately, I fell into Kent County, which is known to dismiss, like they did in my case, and not even consider, the history or the circumstances of my own story. So by falling in the wrong county, I did not have a simple path to achieve parentage of my children.
You both were in probate court, though, right? Is that correct?
I think so.
Yes.
And background for me is I've been litigating in probate for a couple decades now, but I see part of the situation, part of this issue is because of proficiency of the judges or the lack of, and I think you might have been a little bit victim of that too. So I appreciate you hanging in there and getting what you wanted to do. Good job. Thank you.
Thank you.
Thank you both for your testimony.
Thank you all for listening to our stories.
Many blessings on your journey with your little ones. I'd like to call up now Judge Jake Cunningham. Thank you, sir.
Good morning. Thank you, Madam Chair and members of the committee. I am Judge Jacob Cunningham of the Oakland County Circuit Court. I am here today to give the perspective that I have from the bench, having been a family court judge. I think there was some references recently to where the case would be filed, and I'm going to start there. As the law currently stands, and as Michigan currently stands, a circuit court case would need to be filed. Certainly, in Oakland County, it would be filed in the family division of the court. I guess some of our other jurisdictions have an overlapping probate court, family court, concurrent jurisdictions in that regard. But as far as the filing, as I've seen them, they come through the family division. And part of what I think folks are struggling with is that the time it takes for an initial filing of a complaint to make its way before a judge. As we all know, situations with folks carrying children takes time. And sometimes things happen and emergency medical situations have to occur. And when folks are having a surrogacy dynamic, the rights and obligations of the parties, and especially for the children, remain unclear. So when these pre-birth orders, as they've been mentioned today, do come to the court's attention, certainly someone would have to notice a hearing or somehow get the matter before the judge. And when that happens, the judge is faced with the question of determining whether or not a surrogacy contract exists or not. Because as we all know, the state of the law is that there is no avenue for a surrogacy contract. It's prohibited in our law right now, and that cannot happen. So a judge is faced with the understanding of, do we hear testimony and become satisfied that there is no surrogacy contract? Or do we, as it has just been testified to, dismiss the case as there's no controversy before the court for it to adjudicate? That leaves us in an area where we don't have a lot of direction from the legislature in terms of what to do. So what happens? At that point, we have a situation where if there is no a satisfaction from the court's perspective that there's no surrogacy contract in place, the court would hold a hearing or sign an order, and that order would indicate that there's no contract in place, but that upon the birth of a child, hopefully a happy and healthy and safe birth, results in the individuals who intend to be the parents are the parents. But when a child is born in Michigan today, the law provides that the mother is the presumed parent, and even in situations where folks are not married, the mom has an initial custody presumption that can be rebutted later. And as it relates to a married woman, her spouse will be also deemed to be the other child's parent. So if that happens and there's no pre-birth order in place, in order for that child to have the intended parents become the parents, those folks, the person who gave birth as well as that spouse, if any, would have to at first terminate their own parental rights to that child, and then an adoption process, which was described just a few moments ago, would have to occur, which is costly and time-consuming and puts this matter before yet another judge to determine the rights and obligations of this young person who is hopefully, again, happy and healthy that was born. And with that, that's a lot of process for our citizens and for our litigants. And I can say from the bench, I've interacted with many families over the years in my time in the family division, and those folks, it's a struggle. I think we can all agree that dealing with our children and matters concerning our children, our families, are most important, without question. So what happens if the court does not enter or does enter the pre-birth order? If there's a satisfaction from the court's perspective that there's no contract in place and the birth occurs at the hospital and the rights and obligations are set forth, that's what the intent of the surrogacy relationship is. But things happen. And I can tell you that I've always been concerned when these cases have come through the system and I always make sure that folks are understanding there's nothing in the law that protects them or gives them guidance or gives the hospitals guidance as it relates to what to do if something happens. Because there can be no contract, because there is no statute delineating how this is supposed to work, it is a at-risk situation for the folks who are at the hospital giving birth, and for the parents and for the child, and it is a legal conundrum from the perspective. I'm here to just offer my perspective as it relates to what I've seen in court as it relates to these families, but my brain goes to the what ifs. What if during the time and place where if someone is waiting to adopt their own children, a divorce happens? Who has custody? Who can fight for custody? Do they even have a case or controversy? What happens in the hospital if there's no contract or statutory authority to guide the hospital or the families? How do we solve the problem? And especially if there's an issue with the child, how does that child get the medical attention it deserves and needs in the interim, and who decides? These are all questions that run through my mind when I think of this issue. So that's the perspective I'm here to offer from the bench as it relates to what folks in my position have seen through this very specific area.
Thank you, Judge. Appreciate you being here today.
Thank you, Madam Chair.
From what I'm understanding from your testimony, this package of bills will preempt and resolve any number of questions and situations that will arise during the course of a surrogacy in the subsequent birth, thereby relieving the courts of all this extra burden that could come.
I would respectfully clarify it as my understanding. I mean, I'm not here to speak on the bill. I'm here to speak on the notion that there's no guidance right now for family court judges and probate judges. There cannot be a contract to rely on. That's the law. And there is no statutory authority to guide us in terms of making a decision if we're tasked to make one. It is a at-risk situation, and I have seen families where they've had to get the understanding that they are going to go into that hospital and hopefully, again, knock on wood, have a happy and healthy and safe birth. But if something happens, it is an at-risk situation for everyone involved: the gestational carrier, the intended parents, the hospital staff, and the doctors. Everyone is assuming a certain piece of risk because there's absolutely no guidance, either from a contract between competent folks to be able to enter into a contract, or from the law, from the legislature.
Okay, thank you very much. Representative Fink?
Thank you. So I understand that your testimony is intended to be neutral as to the bill today.
Correct.
Have you looked at the bill?
I have reviewed the bill.
I guess one of the questions, I have many questions. I'd be happy, maybe if I think I have at 12 o'clock, maybe we could talk for a minute after this about some of the issues that I'm concerned might be subject to litigation, because of course contracts are intended to work things out that don't always work out. And so of course there's much litigation over contracts. One set of questions that I have relates to section 303G. Yes, 303(1)G of the bill, which says that the agreement must permit the surrogate to make all health and welfare decisions regarding the surrogate and the pregnancy, including but not limited to whether to consent to a cesarean section or multiple embryo transfer. Notwithstanding anything in this act, any provision in the agreement to the contrary is void and unenforceable. This act does not diminish the right of the surrogate under Section 28 of Article 1 of the State Constitution of 1963. That language, Article 1, Section 28, is what was known last year as Prop 3. What I'm having trouble understanding is if a woman's rights, if a woman is a surrogate under, in one of these agreements and her rights under Prop 3 or Section 28 of Article 1 are not diminished, what is the mutual obligation that she's made in the contract? How can she be bound by a contract if Article 1 guarantee and her rights there are not diminished, if Article 1 guarantees that she can do whatever she wants with a pregnancy, which is, as I think we understand Article 1, Section 28 to mean? What is she giving up? What's the consideration? And if there is none, how are these agreements ever enforceable? And if they're never enforceable and they're all void, what are we doing?
Oh, there's a few questions in there, respectfully. I guess I would say this. Again, I'm not here to speak on the nuts and bolts of the bill. That is not what I think my understanding of separation of powers is. Mine is to offer my perspective as today, November 1st, 2023, what at least I have seen and what I think my colleagues across the state have seen when these matters come before our courts.
Representative, we do have another witness coming up that might be able to more accurately speak to the question that you just asked. Okay. Any questions for Judge Cunningham? No? Okay, thank you.
All right. Thank you, committee members. I appreciate it.
Oh, wait, I'm sorry, Rep. Johnson has a question.
Thank you. Appreciate that.
Good morning.
The what ifs, you mentioned a lot of what ifs, and certainly whether this bill package passes or not, we're going to have a lot of what ifs. But it sounds like you would rather have a for-profit business broker-dealer with moms and babies make these decisions instead of you, the judge, having eyes on it?
I'm not sure I understand the question.
You're stating how difficult your job is with what if this, what if that. There's going to be a lot more what ifs once we have a whole business entity and a consumer industry here. You would rather have the broker-dealer of the babies and the moms make these choices and decisions than that goes through a court proceeding for this type of thing? Is that what you're proposing?
Well, I'm not proposing any. Respectfully, Representative Johnson, I'm not proposing anything. My job is hard. All of your jobs are hard. I think everyone doesn't really know how hard someone's job is until they're sitting in the exact chair for which they are serving in. And I'm not saying my job is hard because of I'm not even saying my job is hard. What I'm saying is, quite frankly, is the legislature can do a lot to help citizens of our state by giving us some guidance as to what courts are supposed to do in situations of surrogacy, as have been presented by other folks who have testified today. The inconsistent results, depending on jurisdiction and depending on a judge's interpretation of the law, I don't think does a lot of service to our citizens. So I think it would make my job easier, to the extent it could be made easier, to have some legislation in place to give us a guiding light. I'm not saying that there is a component that I see as a helpful or dishelpful to have a brokerage, as you put it, in between. But I think folks, one of the tenets of our society is folks have the right to enter into contracts. Thank you.
Representative Wozniak, quickly, please.
Really quickly. Thank you, Chair.
Morning, sir.
Thank you for your testimony, sir. Looking forward, and I know you're not a soothsayer, but let's say this bill did pass and participants came into your court, but they had no written contract. How would you rule that? Aren't oral contracts valid in Michigan?
Well, again, I'm not here as a treatise of contracts right now. I think, and again, there's going to be a lot of what ifs no matter what. I mean, there's what ifs as to every bill that comes in, and I think the legislature doing its hard work does the best they can. But what happens is once a bill becomes law and then it makes its way through the court system, we have, for example, the automatic set-aside legislation for criminal offenses. That has been a difficult navigation for trial judges in terms of eligibility, in terms of are some things automatically set aside, are some things not. And I'm just using that as an example that even with the most well-thought legislation and a lot of time and research going into some matters, once it comes through the court system, the what-ifs that we didn't know about, but that we can maybe think about, play out. And of course, as we all know, the lawyers in the room, sometimes bad facts can make bad law as it relates to case law. Mm-hmm. And we do the best we can in terms of interpretation of the law that we receive, and if certainly amendments get made and tweaks get made. But this would, yes, it would enter into an area of contract interpretation if that needed. But I think also with there's two separate, I guess, prongs of how I view this. Whether or not there's a statute to guide the trial courts if needed, and the ability for folks to create their own contracts within the confines of the law that you folks see fit.
So it sounds like you would enforce an oral contract.
Like the judicial canons prevent me from saying about how I would rule on anything.
I know
so
it.
I can't say that.
All right, but thank you.
Thank you, sir.
Thank you very much for your testimony, Judge.
Thank you, ma'am.
I'm sorry, Representative Devendorf, you've got about 30 seconds.
You know I do well with 30 seconds. I think it's a great lesson that bad facts make bad legislation. In this case, however, with this legislation, it is to provide more clarity and more of a process in order to ensure that we don't encounter the snafus and obstacles that this process currently encounters. Would you at least consider this legislation to be some improvement and some clarification that can guide you in your decisions? And would you be open to working with an association like our judges associations on an educational component as to how to apply these things?
I would suggest the first part, any guidance would be more than we have now. And I will start with that. Thank you.
Thank you very much. I note that we had some people come into committee today asking to testify. We unfortunately will not have time to get to some of the other testimony if you had not spoken with me beforehand. However, if I do not call on you, your testimony and your notes will be either noted in the record, they will be reflected in the minutes, because we do have to vote these bills today. I would now like to call on Stephanie Jones from the Michigan Fertility Alliance. And we also have Polly Crozier on Zoom.
Thank you, Chair Breen, and everyone for being here today. So after listening to today's testimony, you've probably concluded we are all here, opposition included, because children are blessings. The opposition spoke in hypotheticals referencing other countries. But the reality is hundreds of thousands of Michigan children have been and will be born via assisted reproduction and surrogacy in Michigan, and it is our duty to protect them. The Michigan Family Protection Act does just this. One point I do want to share that I heard brought up, I think, was by our opposition at Right to Life, and I believe another opposition was regarding the human trafficking. And regarding this argument on trafficking, it's a boogeyman under the bed situation. Shine a light on it, and we see it doesn't exist. They intentionally conflate the two cases they mentioned with surrogacy in a calculated attempt to glom onto the hot-button topic of human trafficking. If you take a pragmatic approach, then why don't we see human trafficking in the 47 other states where surrogacy is lawful and regulated? That's because we live in the U.S., where we have laws that protect our citizens. Legalizing and regulating surrogacy, as this bill seeks to do, helps to combat even the possibility of trafficking by establishing a legal regime all parties need to abide by providing parties legal remedies if and when there are violations. And before I turn it over to my colleague Polly Crozier, I did want to touch on one more thing that I heard brought up, and it seems to be a word that is being taken up, and it's brokers, third-party brokers, and the idea that there is no connection to the carrier. I'm a mother, naturally. My 10-year-old son is in this audience with my husband, and I have a daughter born via surrogacy after nearly losing my life twice over to become a mother a second time. I will tell you I have a deep connection with my carrier. There is no third-party broker, as you're referring to. There are surrogacy agencies that are resources to families like mine, Alex, Tammy's, and the hundreds of advocates we represent who do help navigate the process. If we're going to refer to brokerage, then we would have to do the same for things like adoption agencies that help families navigate the adoption process, which is extremely daunting, extremely expensive, and very confusing. They do no more than act as a resource. So there is no such thing as a third-party brokerage. I will go ahead and turn over my to Polly.
Yeah, thank you so much. Just want to answer a few of the questions that I heard and any others that folks have. Thanks for your time. I just want to say that I do think this package is a vast improvement over the current situation, which is chaos, unpredictability, and uncertainty, and no protections for the person acting as a carrier or the children and families. The bill requires that people acting as surrogates are over 21. It requires an extensive mental health evaluation. I think it's for folks who don't understand the surrogacy process, which I understand is a learning curve for some, these are very rigorous processes, and this bill brings us into best practice to make sure that those processes are in place in Michigan. And I'm glad Representative Fink raised Section 303, which is very clear, and one of the highlights of the bill, which is that the person acting as a surrogate makes all the decisions about her body, all of them, without financial penalty. She makes decisions about whether she has a single embryo so that she's, she makes the decision to end or not end a pregnancy. And that's part of what Stephanie mentioned, which is these are with regulation, very well-run processes that protect everybody involved. And right now, the system isn't working. What Tammy and Alice talked about doesn't work for families. And I have many stories from across the country and the states I work in terrible tragedies, particularly of children unfortunately dying before their legal parentage can be established. And there's no greater heartbreak than having a lack of clarity in parentage for a child who has been so greatly wanted and has passed. So I'll just say, I also wanted to let you know that happy to share with folks afterwards that, there is research, an NIH study that, people acting as surrogates in children, the literature shows are healthy and well-regulated surrogacy practices. There's no risk for people acting as surrogates or for the resulting children. And to clarify that there are, in fact, no protections for unmarried parents who are using surrogacy or assisted reproduction right now because they cannot adopt their own children in the state of Michigan. So there are, in fact, many holes and many children and families who have no protections under the current law. And again, what the package does is make sure that there's regulation and make sure that there's protections and clarity so that people acting as surrogates for children and
Ma'am, I'm going to have to ask you to stop because we have one question and then we need to vote everything out. So I'm sorry to interrupt, but Representative Fink has a question and then we need to vote.
Yeah, I do just want to kind of go back to this Section 303G, which you mentioned, or I guess you mentioned that I mentioned earlier, which says that the act does not diminish the right of a surrogate under Section 28 of Article 1 of our state constitution. My question is, if that's true, and a surrogate can have an abortion at any time and not violate the agreement or at least not be subject to any penalty, then as a legal matter, how is it a contract? Because she's not legally obligated to carry out the terms of the contract or to pay damages if she doesn't, according to what you just said. So my question is, how is this a valid contract at all?
Well, I think I think it goes to the fact that the regulation and that how carefully managed and overseen this process is, right? That well done. The regulations aim to make sure that there's again mental health evaluations, there's medical evaluations, there is extensive engagement between the person acting as a carrier and the intended parents, so that folks have a sense um, that those situations that come up are rare because of that work that has gone into in the process that is designed to ensure a good outcome. Now, but that being said, of course, and it's a very important fundamental bedrock of this bill, a woman who's carrying a baby always has the right to make decisions about her own body.
Thank you. I think that answers the question. I'm so sorry. And one 10-second statement.
Regarding the economic disparity between surrogates and intended parents, I speak for pretty much everybody in this room. Our surrogate was a compensated surrogate out of the state of Michigan, and she was a CPA. So the idea that there is exploitative towards low-income women is been debunked many times over. And we have Mothering Justice, which is a Black and brown women organization who support this package as well.
Thank you very much, guys. I'm sorry that I know there's lots of questions, but there will be an opportunity to continue work on these bills and to ask questions of everybody who's been involved. And I also note again one more time, if you have submitted a card, whether you wish to speak or not, it will be recorded in the minutes today. And now, because we're going to get kicked out of here in a few minutes, we're moving on right now. I'm going to take a motion from Representative Edwards to report House Bill 5207 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I will now take a motion from Representative Tyrone Carter to report House Bill 5209 with recommendation. Madam Clerk, please call the vote. 5208, I'm sorry, 5208. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I will now take a motion from Representative Hope to report House Bill 5209 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I will now take a motion from Representative Arbet to report House Bill 5210 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I will now take a motion from Representative Devendorf to report House Bill 5211 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I now take a motion from Representative Haskins to report House Bill 5212 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglia.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I now take a motion from Representative Cerniglu to report House Bill 5213 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu. Fink.
No.
Wenzel. Wozniak.
No.
Outman.
Yes.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. I now take a motion from Representative Edwards to report House Bill 5214 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yeah.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Yes.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you. Finally, we will take up House Bill 5215. I'll take a motion from Representative Carter to report that one with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Yes.
Johnson.
No.
Madam Chair, you have 8 yeas, 3 nays, 2 pass. The motion prevails.
Thank you very much. I appreciate everybody's patience today and for everybody coming in. Seeing no further business before the committee, we are adjourned.